that sometimes women in India needs to file writ petition before the courts for abortion? And do you know that many Indian women are not allowed to end their pregnancies on their own will? 41% of the women in the world are living in the countries with restrictive abortion laws. Yes, you heard it correct, laws. There are some laws on the grounds of which the women are allowed to abort their pregnancies around the world. Hello and welcome to Developing Success. This is Neha Agarwal and today we will discuss the newly amended Medical Termination of Pregnancy Act. So let me give you some background. So till 1971, abortion was a criminal offence in India under section 45 of the Indian Penal Code. And then in 1971 came the new law by the name of Medical Termination of Pregnancy Act. This law allowed the women in India to end their pregnancy on certain grounds. And what are those certain grounds? So the certain grounds are: number one, risk to the life of pregnant women. Number two, risk associated with injury or mental health. In the terms of injury, we mean failure of birth control measures for a married woman. Mark the word married women here. And also to save the mental health of a woman. For example, some women, if has undergone rape, then that's a condition of mental health and she will be granted to abort the child. And third, fetal abnormalities. That means the child inside the womb, if is having some kind of abnormality like the Down syndrome or like the problem in the heart, then she is allowed to end the pregnancy. But all these three conditions come with time limit, and the time limit is till 12 weeks she can abort the child with the advice of one doctor, and till 20 weeks with the advice of two doctors. And if this 20 weeks period is passed, then there will be a need to file the writ petition in the court for the women to get the permission for abortion. Just imagine, the women needs to move to the court for the permission of abortion. So now this particular certain grounds have been changed in the newly amended act. So let me present to you this table through which we can understand what is the difference between the newly amended act and the old 1971 act. So look at the table. So now the women is just not the women. She is not married or unmarried. She is just a woman. That's progressive. A new privacy clause has been mentioned about the disclosing of identity, and the identity now can only be disclosed other than the designated authorities. And the time limit period has also been extended. Previously it was 12 weeks and now it is 20 weeks with the advice of one doctor, and the women becomes late to decide, then extension of 24 weeks is given with the advice of two doctors. But beyond the 24 weeks limit, there are two categories of women. And what are those categories? The first category is the women with fetal abnormalities. And the second category is the women who is raped or whose mental health is decreasing or whose physical health is decreasing and all that. So for the fetal abnormalities, some scans are done like the ultrasound, like the fetal anomaly scan, like the heart ultrasound of the child. And if some abnormality is found after 24 weeks, then this woman needs to go to the medical board. And this medical board is constituted by the state government with 4 members. And this medical board will decide whether the women can abort the child or not. The other category of the women, that is with the rape survivors or the cases of physical and mental health, there the women needs to go to the court and file writ petition till now. So there is no change. There is just change of timing. 12 has been turned into 20 and 20 weeks has been turned into 24. But beyond 24, women need to go to the medical boards and also need to go to the courts to file the writ petition. So let us know here why these changes have done. And you will be shocked to know a recent case. So in 2019, there was a minor girl, mark the word minor. She was a minor girl and she was not allowed to abort the pregnancy by the Madras High Court because she was late. Because she was a minor girl, she could not understood that she was pregnant, and in the 19th week she approached the court. When the court proceedings were going on and when the court actually gave the verdict, the 20th week had crossed. And after this has crossed, the court said that there is no law beyond the 20 weeks and she has to give the birth to the child. And you know what? She gave birth to the child. Just imagine the plight of that minor girl who gave the birth to the child of her rapist. So this actually instigated the whole matter and the new bill came up in the parliament. And when the new bill came up in the parliament, the other reasons were that now the medical sciences have advanced that much that the pregnancy ending or the abortion can be done into later stages also. Apart from that, the fetal anomaly scan and the heart scan can only be done after 20 weeks. So that is why these changes were there. From here, I will tell you some loopholes of this amended act. So number one, why do we need the medical boards? We don't need the medical boards in the case of fetal abnormalities, and only two stakeholders are needed. The first is the pregnant woman and the second is her gynecologist. Apart from this, the concept of medical board and the concept of two doctors also is completely vague because India has 75% shortage of specialist doctors in rural areas, and in some places the shortage is as large as 81%. So where will we get two doctors and also doctors for the medical boards? Apart from that, this act also talks about some privacy clause. So when a particular woman is going to the court to file the petition, to file the writ petition, so where does the privacy clause lies there? It is no more private. Apart from that, the law is not progressive. Why is it not progressive? Because the women are not allowed to end their pregnancies on their own will and they still have to go through certain grounds. Let me present here some shocking statements around the world. So the countries like Congo, San Marino, Malta, Philippines, Egypt, they still don't allow any kind of abortions. Apart from this, a country like El Salvador in Central America can jail the women for miscarriages. 23,000 women in the world are going through unsafe abortions every year. You know why? Because of the restrictive abortion laws. So the restrictions in the abortion laws can give birth to only two things. Number one, unsafe abortions, and number two, unsafe illegal abortion centers. So there is the list which will never end for the plight of the women who are going through the unsafe abortions. So what is the solution? So solution number one is, why to involve such a big procedure of the courts and the medical board? Why not only two stakeholders, the women and her gynecologist? Number two, more medical practitioners, midwives, ASHA health workers and paramedics should be trained to perform the abortions so that there is no shortage into the rural areas and safe abortions can be performed. Apart from this, the medicine branches like Ayurveda, homeopathic, Unani, Siddha, naturopathy, they should also be given proper training to perform the abortions so that we can meet the demands. Apart from this, the rape survivors should be taken as special cases, and apart from giving them this whole procedures, a counselor and a gynecologist should be provided to them to end the pregnancy. And at last, I will leave you with a question. That is, where does the right of the women of production or reproduction lies? Why are women not allowed to end their pregnancies on their own will? Where is the right of choice? Where is the right of dignified life? And is this law really progressive? Thank you and take care.